I've got the recording on now, so I'll welcome you again. Welcome, everybody. Thanks for coming tonight. Thanks for taking the time. This conference is sponsored by the GDUI Constitution and Bylaws Committee, and I've asked you guys to come here tonight so that we can listen, get a good, accurate information about a really important issue for GDUI. We are considering the acceptance of proposed new bylaws, and we're going to talk about why that's so important and what it means to you. And so we've got a lot in store for the evening. And before we get started, where I'll make some introductions and give some little bit of information about how the evening will go, I'm just going to play some housekeeping material regarding how this conference is set up, and so that everybody can understand how that works.
Welcome to the conference hosted by GDUI Bylaws Committee. This conference is for GDUI members. Only members will be recognized during the question and answer session. If you are not a GDUI member and if you do not have an interest in possibly becoming a GDUI member, please hang up. This conference will be recorded. Caller ID is displayed for callers to this conference. All calls marked anonymous will be dropped. If you want to remain on the call, please be sure to call back with a telephone number that does not hide its caller ID. This conference is in question and answer mode. This means that all participants are muted by default. To place yourself into the queue to ask a question, press *6 and then press 1 to join the queue. If you want to remove yourself from the queue, press *6 and then press 2. Welcome to the conference hosted by GDUI Bylaws Committee. This conference is...
Okay. All right, so that explains how the Q&A session works, and that we are going to be recorded. And if you are an anonymous caller, the anonymous callers will be dropped. That's what we always do. So please call back with a number that can show. And the people that are already in the queue for the Q&A session, we are in what's called Q&A session right now, so that the people who need to speak can be heard. But as far as taking questions from the queue, the actual question and answer portion will be later in this gathering. And so please be patient, and you can remove yourself from the queue by pressing *6 and then 2. So we'll announce when the Q&A queue should begin. Okay. All right. I'm Lori Mehta, GDUI President. Diane Phelps is in the Q&A.
I'm
you
here.
Want to say something, Diane, before, because I was just getting underway? Did you want to say something before I start?
I don't think so. I think
okay.
You've
All
got
right.
a good hand.
Okay, great. All right, thanks. All right, sorry to seem so disorganized. I apologize. My apologies to everybody. I'm Lori Mehta, GDUI President, and I am here with Mary Beth Metzger, who is the Bylaws Committee Chairperson. And we have also with us tonight the attorney who has been assisting GDUI, and in particular who has guided GDUI through the drafting of new bylaws. The board is also here in the call. And the reason that we're here is to talk about the proposed new bylaws. And as some background, the D.C. law changed in 2012, and there were significant changes. So nonprofits incorporated in the District of Columbia, like GDUI, had to make some changes along with it. The Attorney General's office in the fall of 2012 informed us that a few things. One of them was that GDUI's current constitution is not in compliance with the current law. Also, that the board is responsible for conducting, the board of directors is responsible for conducting GDUI's business, and the board cannot hand off that responsibility to anyone else. GDUI was referred to the DC Bar's pro bono program at that time so that GDUI could get legal assistance in getting GDUI back on track with all of its governance needs. And I've been focused on that since that time. That's been my focus, is doing all of this governance stuff, and I'm very pleased and honored to say that the GDUI board has been focused on that too. We've all been working together diligently and working very hard for the past couple of years now to make sure that everything is solid and good for GDUI to move forward for a successful future. We've had monthly board meetings, which is unprecedented for GDUI. We've had open board meetings. All the meetings, the regular board meetings, have all been open to members who wish to call in and listen, and then ask questions at the end and talk with the board at the end. That's also new for GDUI. This is a time for a lot of new things. GDUI has gone through a very hard time, and we're coming out bigger and better in a lot of ways and making a lot of really good changes so that it's better for members and we serve members better. All the while we've been trying to do all of this governance work, we've continued doing the work of the mission of GDUI. Several different projects have been ongoing with regard to the guide dog schools, with regard to working with government entities. For example, GDUI is on the agenda to present at the FAA conference on April 10th. We will be presenting, not just participating as a spectator. So we're doing good things, and it's all because we all care a lot about GDUI. Why are new bylaws necessary? Why are we here? Why are we talking about this? Well, because the current Constitution is not in compliance with the current law. And we don't want GDUI to continue in that kind of a situation because it leaves GDUI vulnerable to having a lot about it questioned, and that's not good for any guide dog handler. GDUI has had great help, and we have this opportunity, golden opportunity, to keep on moving GDUI forward and lay a good foundation for the next board and every other board that will come after it to do the good work that we all care about GDUI doing. So I'm requesting that everybody be patient, listen to what's presented here, ask your questions, please. That's really important. I mean, there is always fear of the unknown. There's always fear of things that are different. It's normal. It's natural. Especially the more different things seem, the more it's something that people approach with a little bit of caution, which is a good thing. And that's why information is good. Education is power. So the board has spent a lot of time trying to educate itself on the laws and on what fiduciary responsibilities of board members are, and we present this information tonight and then on April 7th in an effort to try to help all members. The IRS and the DC law both make more demands on nonprofits to, have their governance practices in good order, and so it's not as much fun as some of the other stuff that guide dog handler advocacy organizations want to be doing, but it's necessary in order for us to continue existing so that we can keep doing the good advocacy work. So please listen, ask your questions. You'll see that the new bylaws, I know that you'll find that the new bylaws gives the members a lot more power than they've ever had before. It takes a lot of the single-handed grasp of power off of what the board can do, and it puts a lot of ability to have a real hands-on relationship with the organization into the hands of members. So these new bylaws comply with the law and standard nonprofit practices, and so I really strongly recommend that members consider carefully and then adopt these bylaws as a foundation from which GDUI can continue to grow on. And as you'll hear this evening, there are policies that can and should be adopted that flesh out a lot of this stuff more, so that a lot of the questions people have about, well, what about this, what about that, that can be addressed through policies, and that's the appropriate way to do it. GDUI's future is what we're here to talk about, because we want GDUI to have a future. So that's why we're all here. And I really thank everybody for taking the interest and the time to come here, to the people that have written their questions in already to bylaws@gdui.org, the people that have come tonight. Thank you very much. Thank you to this entire board, the bylaws committee, amongst them, and thank you to the attorney who has been assisting us. And the volunteer members who have helped us all along the way. There have been so many really helpful things that could have never happened without them. So what I want to do now is let you know that I'm going to I'll give the microphone, if you will, to first to our bylaws committee chair, but then to the attorney. And what I believe that our attorney plans on doing is giving an overview to talk about the law, the changes in the law, the law itself, what it asks of nonprofits, what it asks of board members, going over the bylaws, what they mean, why the things are the way that they are. And then the questions, so many questions that came in already ahead of time, those will be addressed. Now, after that is finished, then I will come back in and I will open up a Q&A session, an actual Q&A, where I'll ask people to please get into the queue at that time so that your questions can be recognized. Each member, only member questions will be recognized, please, because we want members to have the opportunity to talk. And each member is asked to ask only one question. It should be brief, please. It's a time for info sharing, and so we want everybody to have a chance. So it's a time to ask a brief question. And you'll be able to ask a question to me, to the bylaws committee, or to the attorney, or all three. So without further ado, I'll just ask Mary Beth Metzger, our bylaws chair, if she would like to say a few things, and then we'll pass it on to our attorney.
I'm going to make this quick. I just want to add my thanks to Lois for everybody who came here, for everybody who took the time to read the bylaws. I know that how scintillating they are, and to thank you for the questions that you've asked, and to let you know that those questions have been submitted, and I just look forward to to having a very good and solid interchange about these bylaws, and for all of us to learn more about them. I'm good. Thank you.
Is that my cue?
It is.
Okay, well, thank you. Good evening, everybody. My name is Regina Hopkins, and I work for the DC Bar Pro Bono program. Just a little background about me. I am a tax lawyer. I've been practicing law for over 30 years. I started working for a large firm in New York. I then went on to be a general counsel of an international nonprofit organization for 15 years, and for the past 8 years, I have been at the DC Bar Pro Bono program. I first got involved with GDUI when I got a call from Bernard Reskoff from the Attorney General's Office of DC in the late summer, early fall of 2012 regarding the conflict within GDUI, and he asked me if I could help the organization provide them with pro bono counsel. And then at the time, I spoke to, I know her, I think it's Betsy, not Betty, but Betsy Barnes called me, and then Lori called me.
Becky.
Becky Barnes. Okay, thank you. Called me, and, in full transparency, I told each of them that I was speaking to the other and what I was saying to the other. But ultimately, I think Becky decided to take a step back from what was going on, and I worked with Lori and the board to try to sort of bring some order back into the affairs of GDUI. In the last few months, I've been working specifically on help with the bylaws for the drafting the bylaws for GDUI. Hold on just a second, my computer went to sleep. Okay, so some background. Why there's been a lot of questions about why do we have to adopt these bylaws, and what's the rush? Actually, the new law, the DC Nonprofit Code, was amended in 2011, effective January 1, 2012. And I have been, our organization has been spent the better part of the past 2 years and more sort of educating nonprofit organizations in the district and helping them come into compliance with the new code. It's not it's not early. It's kind of a little bit late in the process in terms of coming into compliance for a variety of reasons, most of which having to do with some of the internal issues of the organization that had to be resolved before we could work on this. The code, the nonprofit code for DC was based on the Third Model Act that was published by the American Bar Association. Prior to that, the code had not been amended prior to the early 60s, and so it was very seriously out of date. And it was very bare bones. It didn't set many rules or guidance to nonprofit corporations, and so they didn't amend the code. They just got rid of it, and they completely replaced it with a code that is much more far-reaching in terms of its breadth and scope. There's very little of the old code in the new nonprofit code. It was a very sweeping change in the law. We had the distinction of having been the first jurisdiction to actually adopt the third version of the Model Act. So some of it is a little new in terms of what it all means, but it makes dramatic changes to the law in D.C. So that is why there's a lot of what looks completely different than what you saw before in your prior Constitution. I should say that because some people say there have been some questions, and I'll go into them in a little bit more detail, but I'll just touch on it briefly, that, why are we not following the existing Constitution? Well, you follow the existing Constitution unless there's something in the nonprofit code which contradicts it. And in those cases where if there's a contradiction or a difference between the nonprofit code and the Constitution, you have to follow the law. The Constitution, you can't follow the Constitution in violation of the statute. So that is why there are some things that we are doing that, even though they're not currently provided in the Constitution, we have to do under the law. The other thing I'd like to say is that the bylaws are an internal document, meaning that they govern the internal functions of the membership and the board and its committees and officers. It is not an outward-looking document. It's about how you do things, how you hold a meeting, how you elect directors, how you elect officers. In that sense, people have asked, why is there no mention of the affiliate or the American Council for the Blind or the ACB? And the answer is, it's because that's not the proper place for it. It's designed to be a operations manual and not a mission statement. It's not a mission statement. It's not an external document. I worked for an organization that had over 2,000 affiliates, and there wasn't a single mention of them in our bylaws. We had agreements with the affiliates. There was an affiliation agreement. We had standards of what we call standards of excellence that we wanted affiliates to follow in order to be an affiliate in good standing. There were a lot of guidelines, but that was all those were all in a separate, important document, but a separate document, because it had nothing to how the affiliates acted and operated had nothing to do with how you hold the board meeting. So it's one of those things where there's a place for everything and everything in its place, and those types of policies and procedures, while important, are not really the proper subject of the bylaws. I should say that it's important. Some people say, have asked what happens if we don't adopt the new bylaws? Well, there's no magic thing where you get put in jail or something bad happens to you. It's just, in effect, a ticking time bomb. And what I mean by that is you could go a year, 2 years, 5 years, and nothing happens. And then all of a sudden something happens. And because you have not been acting in conformity with the law, the ability for you to act as a board or as a membership can be questioned in court because you haven't been doing things in accordance with the legally mandated processes. I'll give you a good example. In D.C., we have a guy named Marion Barry who's sort of infamous. Some of you may have heard him. He's currently former mayor, former convict, actually, now city council member, and his ex-wife ran a charity in D.C. That taught tennis to inner city youth, and the charity leased the building from the city. And there was a mayor in office who did not get along with Marion Barry. And so what he did was he found out that his ex-wife, who had a good relationship with her ex-husband, found out that her organization was not in compliance with the D.C. nonprofit code. And what they did was they canceled her lease, the lease for the organization. They said, you're not an organization who's following the D.C. law. We're going to cancel the lease. And her organization had to go out of business. Is that going to happen to GDUI? I don't know. But I can't tell you it's not going to happen, and I can't tell you it's not going to happen next month. That's the point. It's as long as you're operating outside the requirements of the law, then you're at risk that at some point it may come back to bite you. Okay, just a couple of just general concepts, and then I will go basically article by article. These bylaws, as I think Lori mentioned, are very member-centric. And by that I mean that a lot of the decisions that heretofore have been made by the board are now made by the members. For example, you cannot get on the board of GDUI under these bylaws unless you're elected by members. That's not the way it is now. Now certain people like the editor of Paw Tracks or certain and other liaisons are by virtue of being appointed to those offices on the board. Under the new bylaws, they're not going to get an automatic seat on the board. Now, the members can choose to elect them, but they are not required to elect. In addition, under the current bylaws, if someone's elected to a term of office and they resign 1 month in, then the board, the president, with the approval of the board, can appoint a replacement. Under the new bylaws, that's still the procedure, but the person only serves as a director until the next annual meeting, at which point, if they want to continue to fill the term, the members have to elect them to fill the remainder of the term. So in a lot of crucial ways like that, the members control, and it's important to keep that in mind, that the members have the ultimate responsibility for determining who is on the board, and that gives them a lot more power and a lot more control over the organization than they have under the existing bylaws. I also want to point out that the board is, the members of the board are fiduciaries. They have certain statutory obligations to follow the governing documents, to act in good faith and for the best interest of the organization. They have what's called a duty of loyalty, meaning they have to put the interest of the organization first. They have the duty of care, meaning they have to act in accordance with what's in the best interest of the organization, using their best judgment in that matter. And they have what's called a duty of obedience, which means that they must obey the provisions of the Articles of Incorporation, the bylaws, and the laws of both D.C. and the federal government. And they can be held liable if they fail in those duties. And so that's the important thing to say. And that's all ultimately, some people say, what if they do this or what if they do that? Well, they can be held liable. And so that is a much bigger check than anything I can draft in a bylaws. And that makes them different from members. Members are not fiduciaries in the organization because they're acting on their own behalf instead of on behalf of others. And so they're not, although they try to act in accordance with the best interest of the organization, there's no statutory obligation, and they cannot be held legally liable if they fail to do so. So with that in mind, I'd like to just go through the bylaws. The first article is the name. It's Guide Dog Users Incorporated. The purposes, it says the purposes are those specified in the Articles of Incorporation. There's Article 3 talks about offices, registered agent. Every organization and every legal entity in D.C., as in all jurisdictions, must have what's called a registered agent. This person exists in case this person is responsible for receiving official notices on behalf of the organization and ensuring that they are responded to. Okay, Article 4 deals with members, and the first section deals with eligibility for members. For membership. One of the big changes in the D.C. Nonprofit Code is that members have to consent to be members. They cannot be assumed to be members. So people have to agree to be a member. It typically, with a lot of nonprofits with membership, they'd have every one of their donors was a member, or everybody who volunteered was a member. And those types of provisions are not permissible anymore. So now what you do is you sort of set forth who could be a member if they wanted to, and then the board is responsible for actually drafting a process by which people actually join to be a member. And it's just the law provides that two-step process. And now we do add that there is a goal. We talked about before, it said that half the members must be guide dog users. And we talked about the practicality of what happens if some guide dog users sort of resign or leave the organization for whatever reason, or I think some guide dog users become, when they get older, it's no longer practical for them to use guide dogs. So they may have been lifelong members of GDUI, but now because their situation doesn't permit them to use guide dog users, they are no longer users, and they would, you have the situation of trying to have to kick people out in order to keep that 50-50 ratio. So we made it a goal instead of an actual requirement, just to sort of accommodate those fluctuations. Section 402 deals with termination of membership. Before I drafted these, I did a lot of research on membership organizations and specifically on termination. And I looked at a couple of other models, other states' model bylaws on this. It's pretty common, I would say. It's not complete. I wouldn't say it's 100%, but it's a good 80% plus of the samples that I looked at that said that if you fail to pay dues, you're automatically cease to be a member. And that's, I think, just to avoid the situation where you have to you have to vote over and over again to to remove someone from the membership rolls. If someone's membership is terminated for failure to pay dues, they can always rejoin at any time for paying dues. There's nothing in the bylaws that says that that's not the case. You can also be removed for other reasons by a 2/3 vote of all directors then in office, provided that the person receives notice and is allowed to speak to, either in writing or in person, to the directors before their final decision is made. I saw one or two people have asked about why about this provision. I'll address it now as opposed to later. This was probably, there was no, unlike the failure to pay dues, there was no overwhelming way of doing this, with one caveat. Very few, if any of them, had a provision that said you can be removed for cause, only for cause. I would note that the ACB's bylaws do not provide that a member can be removed for any reason. There's no required showing of cause to remove a member from ACB. And the reason is, in my word, I think if you put cause in there, you don't avoid a fight, because then you just fight over what's good cause. It's kind of, as I said to Lori and Mary Beth, it's postponing a fight rather than avoiding one. And so I think that generally speaking, when you draft bylaws, if you're going to give people the power to remove somebody, you don't require the showing of cause, because it can be, in fact, more contentious. And also requires it, because you have to prove cause, it just requires a lot more acrimony and conflict than as people try to prove cause. Let me show you why you're a bad person. It tends to make people feel, it tends to make people's feelings worse doing it that way. And I would note, for example, that the members can remove a director without cause, with or without cause. So it goes both ways. The reason why, now some people do, I would say there was, I wouldn't say half and half, that's probably more precise than I can give you, but there's a lot of examples of people who have the membership remove the bad member, or the board of directors. They're both common features. And I think that in this case, we have a very high threshold. It's 2/3 of all the directors then in office. And what that's designed to do is to require, like, for example, let's say there's 11 directors and 9 show up for a meeting. Well, that's a quorum. And let's say 5 vote to, or whatever, 6 vote to expel a member. Now, that's not good enough, because you need a 2/3 of all 11. And if the 9 directors are there, then I think whatever 2/3 of 11 is, let me do 15. Okay, you have 15 directors and 9 show up, and that's a quorum. And 6 votes is not sufficient. You need 2/3 or 10 votes to remove the director, even though you have a quorum there. So that supermajority of all directors is designed to make it difficult to remove a member. And a lot of people, I know there's been a lot of distrust within the organization over the past 2 years about directors and non-directors. And some people have said, well, this is quiet or it's not open and transparent. And that's true, but that's not necessarily a bad thing. Let's suppose, leaving aside the current situation, let's say 10 years from now, everybody's happy with each other, but you want to remove a member. Now you're going to have to send, if it was by the if it was removal by the membership and you have like 800 members, then all of a sudden you have to mail out the reasons why you want to remove this person to 800 people. Joe groped Mary at the annual meeting. Well, I'm not sure Joe would appreciate that going to 800 members. Or someone is afraid, maybe it's not true. Maybe someone's making it up. But what's Joe going to do? He's going to resign his membership because he has no choice, because he can't risk the embarrassment that what if his wife found out this thing that wasn't true, or what if his boss found out? And so, it can be misused as well. You can, the threat of that sort of public exposure can be just as abused in just the same way as anything else. And so, I think that given the situation, I think it's better to do something more privately, in the same way that if you have a problem with an employee, you don't get up at a staff meeting and start talking about it. You talk to them one-on-one. And I think in most cases that would be more respectful of that person. I would also note that it's extraordinary to remove a member. I was general counsel for a nonprofit for 15 years. And I probably worked with hundreds of people who were on our board, because we had a fairly large board of over 30 people. And I remember one situation where we had to remove a director. It's an extraordinary thing. I think you can focus in on this, but I think it's probably not as an issue as everybody thinks it is. And if you, let's say, for example, that you do have a board that's abusing this provision, it's simple. The members can remove the directors. They have that right, and they don't have to prove cause. So let me move on. Okay, each member who has paid his or her dues is a member in good standing and is entitled to one vote at the meeting. Non-voting membership. There's been some question about this. Basically, it's very common. It's sort of, I've seen it in just about every membership organization I've seen. It's very common to have a bylaws provision that allows you to have non-voting members. Basically what it's for is it's designed to, if you have like kids in school or, spouses of guide dog users or something like that, people who don't necessarily want to pay the dues and may not, just want to show solidarity or support with the organization, then they can you can give them the honorary title of an honorary member without them having to fully participate in the organization. It's designed as a way to reach more people than you otherwise would through your membership. It's not designed to create a two-class system of members. Okay, the meetings, meetings of the members are held annually. I think we have them set in the second quarter of the year, and that's generally a meeting at which you elect directors, receive reports, and other activities. You can also have special meetings that can be called by the president or the board or 25% of the members, and I'll talk about that a little bit later. The members can do it by just circulating petition amongst themselves. In addition, there is, prior to the meeting, you have to give notice to the meeting, of the upcoming meeting, to the members. So the question is, who's a member that's entitled to notice? And this Section 503 allows the nonprofit to set a record date, and that's the date that you essentially close the books and say, this is the members who are entitled to vote and who are entitled to receive notice of the meeting. This is a concept that's every public company in America, a publicly traded company, is required to have what's called record dates. Those are the dates you determine who votes at the annual meeting, who gets dividends, or things like that. So it's a very common, time-honored feature of corporate law. Under the internal, some people have asked, well, if there's nothing in the current Constitution that talks about record dates, that's true, but the statute makes clear that even if there's nothing in the Articles of Incorporation or bylaws, the board has the right to set a record date. And the statute also provides, this is in Section 405(d), if it's not otherwise fixed by the bylaws or the board, the record date for determining members entitled to notice of and to vote at an annual meeting is the day before notice is given to the members. So the law requires a record date. It's not optional. It's optional whether it's set in the bylaws, or whether it's set by the directors. But if the bylaws or the Articles of Incorporation are silent and the board does not set the record date, then the statute sets the record date for them. And so that's why that provision is there. There is a provision for notice of the meetings and the time frames in which they're given. Those are within the parameters set forth in the statute. The notice is delivered in the form of what's called a record. Generally speaking, in this case, it's delivered by, I think, mail or email or U.S. mail. The statute is very forward-thinking in terms of allowing how notice can be given in terms of electronic communication, and a member can waive notice by participating. The quorum is what is set in the existing articles at 15%. The president presides at the meeting. That's sort of the default thing. The member may not vote by proxy, and that's a carryover provision. And a simple majority unless it's otherwise provided, and there's what's not called cumulative voting. What that simply means is if there are four openings on the board, you have 4 votes for 4 different people. You can't cast all 4 votes for one individual. That's what cumulative voting is. Some publicly traded corporations have it, but most don't, and it is considered, and it's not permitted here. You can meet by telephone conference or Skype or some other electronic communication. And then there is a new provision in the law, and this is brand new. It never existed in the law. It's action by recorded ballot, which is, and I want to make clear, it says any action required or permitted to be taken at an annual or special meeting may be taken by ballot. So anything, whether it's election of directors, approval of the bylaws, election of officers, anything that could be done at a meeting can be done by ballot. And the ballot can be what is called in the form of a record, which is inscribed on a tangible medium or stored in an electronic or other medium that is retrievable in a perceivable form and sent to the member personally. And what that means is that you have to be able to listen or read the ballot and reread it or re-listen. So you have to be able to look at it, say, okay, put it down, and then come back and read it again. So that's why if I called you up and asked you, that would not be permissible because I can't retrieve it. But voicemail is acceptable. A recording like this is acceptable. Anything in writing is acceptable if you can retrieve it. And that is what is required in the statute. Basically, in order to be approved, any measure voted on by ballot must be approved. The number of votes cast must equal what the quorum requirement was, and the number of people voting in the affirmative must equal what would have been required had a meeting been held. And all of that has to be set forth in the ballot. So I think in the ballot you received with respect to the bylaws, all that is spelled out. Okay, I'm looking at the time and I want to move quickly. Basically, the board of directors, they operate and they oversee the day-to-day operations of the organization. The members set the big things like who's going to be on the board. It sets other things like who's going to be on the board. It sets major corporate transactions like mergers or things like that. But the directors do all the day-to-day stuff. The board has the officers are members of the board. In addition, the members can elect anyway from 3 to 6 additional members. And the reason why there is a spread as opposed to a fixed number is again so that you don't inadvertently go out of compliance with your own bylaws. So let's say if I have seen bylaws that say 15 members, well, 2 resign. Now you're not in compliance with your bylaws. So you give yourself some wiggle room there so you don't inadvertently come out of compliance. The new directors and current directors can be reelected for 2 terms. Partial terms are counted if they're over half the length of it. The committee of the board is responsible for soliciting nominations, and it is the goal to develop a list of candidates that represents the corporation's diverse constituency, and a list 50% of whom are guide dog users. Again, this is designed to, it's phrased in the form of a goal because, sometimes it just doesn't work out that way and you don't want to have a problem with that. Generally speaking, only members can remove a director. And as I said, it's the affirmative vote of 2/3 with or without cause. The board does have a limited right to remove directors, and this is, again, right from the statute, and that is if there's been certain bad acts on behalf of the director. If there's a vacancy on the board will fill it temporarily until the next annual meeting when the permanent replacement can be elected. The board can meet annually, and they have an annual meeting, which is sort of the first meeting of every year, and then they can have regular meetings like monthly or whatever, and then special meetings on shorter notice. And there's some notice provisions. I won't go through them. They're pretty self-explanatory for letting directors know of an upcoming meeting. They tend to be much shorter time frames than notice to members because of the it's a smaller group. The directors can meet by teleconference, or they can act by unanimous written consent. And finally, they serve without compensation. Officers are the president, the 2 first vice presidents, the first vice president, the second vice president, the secretary, and the treasurer. The officers are elected for 2-year terms. Again, there are partial terms. There are term limits on this for the, vice president and the president. The election of officers can take place during the annual meeting, but again, that can be done by ballot if appropriate. The president and the vice president, there is a committee appointed, and this is something that I've seen several places, and I just want to make it clear. The board has a committee to solicit people's nominations for officers. The committee, in effect, lets everybody know that they're looking for candidates for office. They may affirmatively, send notices to people and things like that, to ensure that there is a robust pool of candidates. And then they confirm that the candidates are eligible to serve as officers. And what they do, and the eligibility requirements are 2. In order to be an officer, you have had to have been a member in good standing for 12 consecutive months prior to the date of the annual meeting. And the president and the vice president must be guide dog users. That's it. People have said that the board can determine who is eligible or not eligible, and they can pick and choose who will be a candidate. That's not true. There is a committee, and all they do is they confirm, has this person been a member for the past 12 months? and is the candidates for vice president and president at the time of their election guide dog users? If the answer to those two questions are yes, then that person can stand for office. And in fact, if there's more than two candidates and no candidate receives more than 50% of the vote, then there's a runoff with the top two candidates. Officers can be removed by the members, again, with without cause by a 2/3 vote, and the directors can remove them again upon certain bad acts. Board committees. Let me just take a second here because I know I'm going fast, and I'll slow down just a second. Under the nonprofit code, they basically, one of the biggest changes they made was to committees. The code divides committees into two types. One are what are called board committees, and the other are what are called advisory committees. Board committees are committees that have the right to take the type of decisions, make the same type of decisions as a board could make. For example, if you had a finance committee, they could be given the authority to approve a budget. Or if you had an audit committee, they could be given the authority to select the auditor. These are decisions that normally would be done at the board level, but the board has a right to delegate them to board committees. Because these board committees have that authority to exercise fiduciary duties on behalf of the organization, how they're created and who can serve on them is restricted. Specifically, in order to have a board committee, the board of directors must vote to approve it, and it's not just a majority of the directors at a meeting. A majority of all directors must vote to establish a committee of the board with that type of authority. In our example, if there are 15 directors, then at least 8 of them must vote to create a committee. It's not enough if 9 show up at a meeting and 5 of them vote yes. That's not sufficient. You need the vote of at least half of all directors. In addition, before anybody can be appointed to that committee, and they must receive the approval of half of all the directors. And the only people who are eligible to serve on these committees are directors. So if you may be a great finance person, but if you're not a member of the board, you can't serve on a finance committee if that finance committee is going to be given the authority to act on behalf of the organization. That is a big change in the law. It's certainly a change that's different than anything that you'll see in a lot of state laws, but that is what the law is. It's because the nonprofit code is very keen on the fact that directors are responsible for running the organization, and they're fiduciaries. They operate, they're subject to the duties of care and loyalty and obedience that I talked about, and they cannot just delegate that authority to anybody. They can only delegate it to their fellow directors, and they can only do it upon the approval of half of all the directors serving. Then there are advisory committees. Those are completely different. Those are the committees that don't have decision-making authority on behalf of the organization. They only advise, and anything they recommend must ultimately be approved by the board. For that reason, they can have both board members and non-board members on them. You don't need an absolute majority of the board to approve them, and there aren't the same requirements as to appointing people on those committees. Some people have asked, why do the bylaws not refer to the names of the committees? I would say for the past 10 to 20 years, it has been considered a best practice not to list the committees. What you do is you just give the boards the authority to create the committees. You don't list what those committees will be. I haven't seen a bylaws drafted within the last 10 years that had a provision that actually listed committees. And the reason is they change. Sometimes you want to have the right to change committees, or to say that used to be something that the Finance Committee does, now we're going to give it to the Audit Committee, or, we had a Program Committee and we want the Public Relations Committee to do it. You want to be the freedom and the flexibility to move things around or replace committees or change their duties. What you typically do is you vote to appoint a committee, create a committee, appoint it, and you give them a job description, an actual written job description. And that's one of the things I've talked about with the board is the need to have job descriptions for your committees so that everybody has a clear understanding what the responsibilities are. And you don't want it sort of so locked up that as needs change, and they can change pretty quickly, you don't have to go through the more cumbersome process of amending the bylaws to reflect those things. Article 9 is indemnification. I won't go through all the nitty-gritty of it, other than to say that indemnification is something, this follows almost word for word the statute, and it is basically the right, if you have a director operating in good faith, trying to do the best they can, following the law, and they get sued, and they have the right, the board has the right to indemnify them for their costs. The costs of that are funded through the directors and officers insurance. That's how it's taken care of. Article 10 is miscellaneous. It reiterates, this is sort of the magic language from the IRS about your tax-exempt organization, that you have a fiscal year. A corporate seal is just you don't have to have an actual physical seal, but you can sign contracts under seals in order to extend the statute of limitations. If there are provisions that give the president or the treasurer the authority, if you happen to own stock, to vote the shares of stock, to execute documents, to maintain bank accounts, etc. Those are sort of ministerial things because someone has to be charged with the responsibility of taking care of those things. Generally speaking, the members can amend the bylaws at any time for any reason. The directors can also amend the bylaws, but there are certain exceptions and carve-outs that are set forth in the statute, and these basically provide that amendments that affect a member's rights have to be approved by the members. So you can't adopt these bylaws and say, we're going to change everything now that you've approved them. Anything that is that generally affects, and they're listed there, affects the rights of members with respect to voting, or relates to the manner of termination or suspension of members, requires cause or other definition for the removal of a director, changes the number of terms of directors that are currently in office, or relates to the manner of levying of dues or imposing special assessments, has to be approved by the members. The effective dates of these bylaws will be effective once they're adopted. However, as is standard practice, and I think statutorily required, no amendment can truncate an existing officer or director's terms or add additional requirements to them. And that's basically, if you think about it, you want to ensure that people who are elected aren't sort of eliminated by amendment. So that's the reason why that provision's there. I think, let me go through some of the written questions that people have had, and there's been a lot, so I will go through them sort of one by one, and some of them I think we've already answered. What is the rush for adoption is the first one. Well, actually, it's not a rush. We're actually a little bit late. For about 2.5 years after the law went into effect. There is a question about why 25% of the members are needed to call a special meeting, and that the statute, under the statute, it can be anywhere from 10 to 25% of the members can call a special meeting. You have the option of picking any number between 10 and 25%. It can't be less than 10%. It can't be more than 25%. The reason why we picked 25% was this is a small organization. It's different if you were the Knights of Columbus, which has literally tens of thousands of members, and the physical task of getting 10% of 50,000 members is 5,000, and that's a big difference just physically of just getting the manually writing to people and calling people and stuff to go from 5 to 12,500. And so that's a big deal. But this is a small organization. And, it's not the same burden to get up to 25. At the same time, if let's say you had it at 10%, well, that's even less than the quorum. So you may have 10% of the members saying we want a special meeting. And you may not even, and so you have to go to the cost and expense and delay of a special meeting without no assurance that even a quorum of people will show up. Basically, if 89% of the people don't care enough about your issue or don't agree with you, then there's no chance that what you're doing is going to get adopted. And so you're putting the organization through the considerable cost of either convening a physical meeting someplace and having people come, the cost and expense of coming to that meeting, or the cost of the electronic methodology. And there should be a certain threshold of interest in the issue before you put the organization through that type of expense. And so I think that I can't predict it, but I can't be certain. But I think that except for very large organizations, I think you're going to find that the overwhelming number of corporate organizations are going to be at the 25% level, just so that there's some sort of sense that this is a real issue for the members, and therefore the special meeting should be called. I would add that the president can call a special meeting and the board can call a special meeting, so there are multiple ways of doing it. I wonder, there's the removal and resignation of a director. The members may remove it. If the members put that on, if the members at a meeting can basically, if they want to vote to remove the director, it will go on the agenda. The president can't just say, I'm not going to do it. I'm not going to put it on the agenda. If a motion is made at the meeting to remove a director and it carries, then it's done. There's no real way to quash that. Someone says, so telephonic voting doesn't count for elections. Yes, it does. But as I said before, anything that can be done at a meeting can be done through electronic voting. Okay. Then there's another one about the record date. I think I went into that in a lot of detail about why we have a record date. It's mandated by the statute. It's not optional. Some people have asked why there's no reference to Robert's Rules of Order. Again, this is, when I draft bylaws, I follow this rule. Do what you say and say what you do. Your bylaws should follow your practice, and your practice should follow your bylaws. And if they're out of whack, then something has to change. Either you have to change your practices or you have to change your bylaws. It's been my experience that people tend to cut a lot of corners when they're having meetings. They don't if things aren't going well, but when generally speaking they cut corners. I'll be in a meeting and someone will say, I move to do that we do X, and everybody goes, yes, and I'll be like, wait, you got to have a second. And usually you have to slow things down to make sure the proper procedures are followed. And so I try to make the procedures as simple as possible and as less formal as possible, because it's just my experience that people don't bring a lot of formality to it. It would be different if you were a large organization like the Knights of Columbus or the Lions Club, and you had thousands of members and a staff that could sort of patrol or these things. But generally speaking, smaller organizations are not, the process is not their strong point, and so you want bylaws that are that don't sort of end up with inadvertent defaults. Well, that wasn't a valid action because you didn't follow this procedure or that procedure. You didn't dot this I, you didn't cross this T. And so that's why we tend to try to make it as simple as possible. let's see, board powers. Again, I think this is the question about terminating members by the board as opposed to the membership. Again, I just feel that depending on the facts and circumstances, a lot of people may not feel very good about such a public proceeding. Is there a specific date by which everybody had to come in compliance? Yes, that was January 1, 2012. If they do not pass, what happens? Well, like I said before, if the bylaws don't pass, you're not in compliance with the law, you're at risk at some point at an unpredictable date in the future. You will end up before some sort of administrative body or legal body or in court, and you will you'll be in trouble because you are out of compliance with the law. And there'll be a question about who is validly elected, who are valid members, if was something a valid action, did you have the authority to do something, et cetera, et cetera. And it's just a risk that no good lawyer would advocate that you do. And that's the same question to the next one. Again, this is one, why isn't there a clause governing termination that requires good cause? Again, like I said, I think you just end up fighting about what is cause. I note again that ACB doesn't have a cause requirement in their bylaws. Okay. Are the proposed bylaws a replacement for the existing GDUI Constitution? Yes. It is being presented as an up and down vote. Why is the board being empowered to amend the bylaws? That's done by statute. Does the elimination of reference to ACB mean that there's a disaffiliation? No, it just means that this is not. The bylaws, again, are an internal document to the organization, and it's about the internal operation of the board, of the organization, how it conducts board meetings, how it conducts membership meetings, how it appoints committees, things like that. It's just not whatever relationships with affiliates, either BGUI affiliates or ACB, or while important, don't belong in this particular document. They asked about the meeting in the second quarter. It's my understanding that that's generally how it's been held. The status of affiliates is really unchanged by the bylaw. It's just that will be dealt separately in a different document. Where can a plain English explanation of the new DC code be found? It's available online. I think I gave Lori a copy of one that we did that I think they're going to make available to the members, which is, you may not, it cut me to the quick, but one person said, these are very legalistic bylaws. And I felt like, but that's what they are. They're legal documents. And we have tried to generally explain them in as non-legalistic a way as we can. But these are legal concepts, and it can't be completely eliminated. So, but there will be a general overview of the law available. What's the status of the rules contained in Robert's Rules of Order? I think for the reasons that I just talked about, I generally don't recommend that be followed. And then there was, again, a question about removing members. Good. Again, question about affiliates in ACB. Someone wanted a detailed explanation of the changes and why they were required, and I think the call is intended to do that. They wanted it in writing, but to be honest, there's so little overlap between the old law and the new law that you would be explaining every word, and to put that in writing would be a Herculean task. And I think we have an overview of the law. You have these calls. We're answering questions. I just don't think you need a written explanation of this person wanted a written explanation of every change, a written comparison between the old and new, a citation for every provision in the law, and an explanation of how the provision complies with the law. And, that would be a task of hundreds of hours to do that. So I don't think it's necessary, and I think that it just would slow things down unnecessarily. Okay, there's another question about the record date and the removal of members. Someone had a point of order. They wanted to know why it didn't go to the Bylaws Committee for 90 days before it went to the board. I read through that provision. I think what they're saying in that provision is that if a member, for example, wanted to put forward an amendment to the bylaws, they would have 90 days. The bylaws the current bylaws give the Bylaws Committee 90 days to review it before they recommend or an approval or disapproval by the board. If the Bylaws Committee itself is generating the amendment, I don't think that 90-day period is necessary. We've been working on it for 90 days, I will tell you that, and it did go to the board for its approval and recommendation. So in that sense, I think the procedures outlined in the current bylaws for amending the bylaws were followed. This one asks about why is the meeting being held in the second quarter? And then it says, it seems to say that the organization's tax-exempt status is based on the 1986 code. However, isn't there a continued status determined by the current codes, which tends to change? And there actually is language. Basically, they say, should you reference the the Internal Revenue Code gets amended every 30 or 40 years. And so when I first graduated from law school, it was the Internal Revenue Code of 1954. And then it was the Internal Revenue Code was last completely redone in 1986. So all references to the Internal Revenue Code say 1986. And the person asked, well, what if they change it again? But your document says the Internal Revenue Code of 1986. Won't it be out of date? And there is a provision in the bylaws that says that it will act as a corporation exempt from tax under Section 501C of the Internal Revenue Code of 1986 or corresponding provisions of any future internal revenue law. So it does have a provision that if, in fact, there's a new Internal Revenue Code somewhere in the future, that a reference to the 1986 Internal Revenue Code will automatically be updated. Someone wanted to know why the officers and directors are not being elected at the same meeting that the bylaws are done. That's because the bylaws, the current provisions for electing officers and directors do not conform with the statute, so you have to amend the bylaws to get them in conformity so that you can have a valid election. So it's clear that the election held is valid. Has the proposed constitution been shared with the ACB Credentials Committee? No, because it shouldn't be. This is an internal document. It's not something that any other external organization has the right to approve or disapprove or change. It's the responsibility of the board and the members. The board is fiduciaries, and it's not something they can delegate to somebody else. Same thing about the more questions about the affiliates. They say we don't specifically state how much the dues are. That is very unusual to have a dues actually set forth in the bylaws. Generally, it's set because of costs of things. It's set from time to time, typically by the board. Let's see. This is one where someone says, it seems to me that it's a lot of legal speak. I'm sorry, I'm a lawyer. What can I say? It is a legal document. Corporations are artificial constructs of the law, Mitt Romney notwithstanding, and so it's governed by the D.C. Code and the Internal Revenue Code. Those are legal documents, and so it's going to come across as a little legalistic. I think as you get more familiar with it, it will not come across that way. It will just seem like second nature, but that's the provision. Someone said, what would happen if we don't pass the bylaws? I've answered that question. Here's one. I'm not sure exactly how this came. So colleagues, I hate to be the bearer of potential bad news, but if GDUI is incorporated and is a 501c3 entity, ACB cannot suspend or drop GDUI as affiliate, and the funds, if they do that, the funds in the GDUI treasury that is now theirs will remain theirs until such time as GDUI is defunct or dissolved. Then the assets will be distributed in accordance with its constitution and in compliance with IRS regulations. And they make reference to the fact that if it's dissolved, the funds actually do go to the American Council of the Blind under the current under the Articles of Incorporation. And that's right. If ACB doesn't have the right to dissolve GDUI, they don't. Only the members have that right, and their funds remain with them because that's in keeping with the law. When I make a contribution to a nonprofit organization, I want it to go to that nonprofit organization for their mission, and the law is very clear that those wishes have to be respected. They can't use your contributions for some other organization, and nor should they. If I wanted to transfer money to ACB, I'd give it to ACB. The fact that I chose to give it to GDUI is a pledge, is that, and that funds are held in trust by GDUI to be used in accordance with their purposes. And generally speaking, it can only be changed if I give my permission as the person who gave the money, or if under court supervision. And so that's the way the law is, and the way it should be, because it's most respectful of the rights of members. And then next one is a letter from Penny Reeder, Will Burley, Don Brown, Betty Granovich, Marla Hanson, Lynn Merrill, Pat Hill, and William Skates. And I'll just read parts of it because it's a pretty long letter, and I don't want to take up too much time. They say a thorough analysis of the proposed bylaws leads us to conclude that the GDUI board efforts to fine-tune its governance have resulted in a near elimination of members' ability to play an active role in the decision-making process of the organization. That's factually not true. As I said before, the members actually have more rights under this bylaws than the other. They are the only ones who can elect directors. No one can get on the board through appointment by the board or by the president. Any partial term or resignation is filled by the members, except for only on a temporary basis. So there actually is a lot more authority for the members. They have more control than they did before. GDUI's constitution is a living document which has served its members and its evolving mission well over more than 4 decades, while conforming with the requirements of the District of Columbia law. We believe GDUI is fully capable of continuing to conform to the requirements of the DC Code without sacrificing members' ability to fully participate in the organization's governance and operations. Well, they're not. Or the long-held rights of state and regional GDUI affiliates. Again, nothing about this changes the affiliate status. Or the long and mutually rewarding relationship with the American Council of the Blind. Yet some of the colleagues' changes which the current GDUI board proposes would jeopardize or eliminate all of these defining attributes of our organization. I would say I first got involved, I don't know what this organization was like 10 years ago, but I first got involved in 2012, and I cannot say that this has been a mutually rewarding relationship, at least during what I've seen, of a well-run organization. It has been a very dysfunctional organization for the past 2 years. I don't mean to, I'm sure the people who acted in August to try to replace the elected board with a steering committee did so because they were fully committed to the mission of the organization. But the fact remains what they did was outside the construction of the law. I'm sure that was not their intent. I know when I talked to Becky, that was not her intent. But that was what, in fact, happened. And so we have spent much of the past 2 years trying to bring GDUI back into good governance. And I can just tell from a lot of these questions that there's still a lot of really hard feelings, and it's very sad to read some of these questions because it shows just a real breakdown of trust amongst the members. And it's taken a toll on the mission of the organization. Lori has talked at great length about how much they've tried to carry on the work of the organization, but it's just debilitating. It just is. I've seen it in other organizations, and it takes a real toll. And so I would say that the old Constitution really didn't protect the organization the way it had to be. And I think a little legal speak will serve the organization well by setting forth clear parameters within the law and the nonprofit code so that these lingering problems can finally be dealt with. Their letter talks about how the bylaws amend some provisions of the bylaws without member input. That's true, but none of them that affect members' rights. They're more ministerial in nature. Dismiss members without cause. Again, that's the same as ACB. Define membership criteria without member participation. As I said, because of the change in the statute, what you do is you set forth the general eligibility of who can be a member and allow the board's responsibility for actually administering the admission of members because of the consent requirement that's put in the statute. Set amounts of dues without member participation or authority. Again, I think that's the norm. Certainly what I saw is to allow the board to periodically set dues. Establish and define a second class of non-voting members. That's not the case. I think we talked about how the fact that there can be non-voting members is designed for you to, for example, have kids in school or spouses or sort of honorary members, people who can have some sort of outreach and connection with the organization without having to take on the responsibility of being full members. Is designed as an outreach effort that people use in the same way that public television has members. You're a member of public television. Well, you're not legally a member. You don't vote for the board of directors, but they give you that name as a way of maintaining that connection with the organization. And that's what this is intended as well. Public rate, NPR, AARP, it's very common for people to have honorary non-voting members. And it's designed to create that bond with an individual without having to give them governance rights. It allows the board to determine who may run for office. That's not true. There is essentially a nominating committee, but that only screens people to make sure they meet the minimum qualifications. Give the president and board unchecked power never before seen in the history of GDUI. That's just not true. They actually have less power than they had before under these bylaws, and because they can't, for example, make replacement directors, or they can't appoint people as a contract editor or something and put them on the board, and they can be removed by the members with or without cause. So they go through the class of membership relationship with ACBI. The committees, they want to know why the committees are not specified. Again, that's considered bad practice. A best practice is not to detail every committee, but rather just put provisions in that allow the board to create committees. Okay. Someone asked, is there a provision that says that, I addressed that, I won't go through that. Someone asked about reinstatement. Again, if you're suspended or terminated, your membership is terminated because you didn't pay the dues, then all you have to do is join again and pay dues and get joined again. There's nothing magical about that. Some people, one person asked, is there a means for monitoring elections? The statute does have a provision that allows the board or the organization to appoint election inspectors who sort of inspect the ballots and the like, and then they give their findings to the board, but the board is ultimately responsible for determining who is eligible to vote and whether votes are validly cast. That's in the statute. Certainly the board has an electronic voting process in place done by a third party, and I would say that, what they're doing is, consistent with the statute in that regard. Let's see. Oh, that's another question about urgency. And then there was another question from all the individuals that I mentioned before, Penny Reeder and et al. And they said there are 4 questions. The first one is termination of members, which we have addressed. The second is we don't have to have a record date. Yes, you do. And if you don't set one, the statute sets one for you. It's not a violation of the Constitution. The statute clearly gives the board the right to set a record date. And if they fail to do that, as I said, the statute sets it for them. Robert's Rules of Orders, we've discussed. People want to know why that's not in there, and I discussed why. And people wanted someone to monitor the elections. As I said, ultimately the board is responsible for ensuring the good conduct of elections. So that's all the written questions I have. Lori, do you have other questions?
Hi, Regina. Thank you so much. I think that your clarity and directness is going to be very, very helpful for everybody who was listening tonight, as well as all the people that hopefully will listen to the recording. It is now, what time is it right now? 8:30. Okay, it's 8:27 right now. We currently have 4 people in the question queue.
I think we can handle that.
Okay. All right. If other people, should I invite other people to join the queue at this point, given the hour, or what?
Well, let's see how quickly. I'll tell you what. If they want to join the queue, they can. Let's see how quickly we get through the 4 questions we have.
Okay. A reminder to people how to join the queue or leave the queue. Here's the instruction. You press *6, and then you would press 1 to join the queue. If you're already in the queue and you wish to leave the queue, you would press *6, and then you press 2. Okay? Okay, Diane Phelps, and Diane is a board member. Diane, do you have a question for
Lori? I think that my name remained up in the queue.
Okay. All right, then we'll just take you out if you didn't want to. Okay. Thanks, Diane. Okay. Bob Hache.
Thank you very much for the opportunity to participate in this meeting this evening.
And who do you have a question for the Bylaws Committee, or do you have a question for the attorney, or both?
Actually, for the attorney, actually. I'd like you to expound a little bit and be a little bit more specific about how the current bylaws voting provisions violates the new statutes. In other words, why we couldn't have voting for officers at the same time that we voted upon this new Constitution.
Well, the current bylaws don't specify a record date, so we'd have to do that. Let's see. Let me go through the existing bylaws and the current one. There's you want provisions, proper notice. You want runoff provisions if more than one people run. There is the new requirements of a year, being a member for a year. That's pretty common. Usually it's done in a number of ways to ensure that someone running for officer has some experience with the organization. You see it in a number of ways. Sometimes they'll have a nominations committee that truly screens people. So I'm a member of the D.C. Bar. Under the DC Bar, there is a nominations committee, and people put their names forth, and they come up with 2 candidates, period. If 10 people put their names in, they will go through, and they'll weed them out based on, what they feel is appropriate, and they will come down to 2 names. Some people do it by having what's called a president-elect, so that somebody gets as a president in waiting, and they serve as a president-elect for a year, so when they come on the board, they've been a member for a year. And they've sat in on board meetings and participated, so they have that run up. Those are more formal ways of doing it. Obviously, the nominations or screening committee, where they're truly screening people, is a problem. So what the simplest way to do it is to just say you've got to have some sort of, experience or track record with the organization. That's not a violation of law. The things about the record date is a problem. There's nothing in the current bylaws, like I said, for runoffs. That is added in the new bylaws. I know that I'm leaving out stuff. There is those are the ones that come to mind.
There was a residency requirement that
we eliminated. That's right.
Because it caused problems that you pointed out that led to problems in terms of limiting who can run based on some crystal ball prediction of who might win. That's unfair to people. And
yeah, there were a lot of problems. Some of it was statutory. Some of it was just logistics. The existing bylaws weren't really conforming to how you were doing things. So it seemed much better to sequence it, have the new bylaws, have the rules laid out in accordance with the statute and best practices, and then go to part 2, which is the elections. And second, you've already gone over 2 years without complying. It just makes sense to get it done as expeditiously as possible, rather than wait another 4 or 5 months or however long before you deal with the problems. I guess the other thing, there's no reason. I mean, I'm not sure I see what the value of doing them together is.
Okay, thank you. Thanks very much. And then our next person is, I believe it's Maria Hansen.
Hi, yes, I am Maria. And for Regina, our current Constitution, by the way, does have a runoff provision for officer races. And our Articles of Incorporation allow for multiple groups of members, but specifically state that they all have the right to vote. But my question to you has to do with termination of membership in the provision that 2/3 of the board can remove a member, and their only appeal is to that very board that's expelling them. If a member's behavior is so onerous, there is a justice system outside of GDUI, and I believe in the 40 years of our existence, there has never been a need to expel a member. Is there any requirement in the code for GDUI to have this provision? I don't see it.
Okay.
Before Regina answers you, Maria, I would just like to say that I really want this to be very clearly known. The board has no wish to remove anybody for political reasons, if that's your aim, if that's your worry, if that's your concern. The board's concern is to protect GDUI and its good name from being besmirched from something really hideous. And I do give the example of the handler of Leader Dog Inky. Thank God he was not a GDUI member, but I will tell you that when I was serving on the board at the time of the Inky incident, I received multiple phone calls and multiple emails of people horrified. Oh, my God, is he a GDUI member? Is that what you guys would condone? Is that the kind of guide dog handler rights that you condone? And I told countless people, no, no, and no. And I think if something hideous like that happens, I think that the board it would be acting responsibly to be able to say, look, you're a persona non grata. You don't stand for our mission, and we don't want you. And I'm sorry to interrupt in, but that's extremely important because that's the focus of this in terms of the board. Regina, I'm sorry.
Yeah. First off, I understand that the articles refer to members. Let me make clear, under the law, under the DC Code, a member is defined as somebody who has voting rights. If you don't have voting rights, then you don't meet the legal definition of member. Now, the organization can call you a member just like NPR does, or public television, or AARP, and that's the honorific that they give you. But it doesn't mean that you are a legal member. So the fact that there are a provision for non-voting or honorary members, is not. And so I just wanted to make that clear. And it's and we make very clear that this other group does not have voting rights. It's not intended to be a member within the meaning of the statute or the Articles of Incorporation.
Regina, could you repeat a portion of that? I'm sorry. Something happened on my phone. It sounded like it went quiet for a moment.
Okay, I just wanted to say that non-voting members, the statute defines, for statutory purposes and thus for purposes of the Articles of Incorporation, members have voting rights, and if you don't have voting rights, then you don't meet the statutory definition of members, regardless of what you're called. For example, NPR, I use the example of NPR or public television or AARP. A lot of organizations have quote-unquote members, but they aren't members within the meaning of the law. And it's done as an honorific to the person or an outreach. And we make it very clear in the bylaws that these people don't have such rights. And so it's not intended to be inconsistent with the Articles of Incorporation. Rather, the Articles of Incorporation refer to members within the statutory sense, and this is designed to give you the flexibility to have sort of honorary members. That's all. And it's not, in that sense, it's not inconsistent because it makes it clear that they're not going to have, the non-voting members should not have any of the rights granted to members under the Nonprofit Code, the Articles of Incorporation, or these bylaws. And so it's made clear that we're talking about apples and oranges. As to the removal of members, like I said, there is a process. A 2/3 vote of all directors. They do have a right to respond. I think depending on the facts and circumstances, that's a much better solution than having it done publicly at a membership meeting where the person could be embarrassed or humiliated fairly, unfairly. I mean, some people can be members can be just as arbitrary, if that is their bent, as any member of the board. And so I think that I just don't think that one is, if that's your concern, I don't think it's clear that one is superior to the other in terms of either method can be abused if that's what people want to do. There are circumstances where you can remove somebody for doing something that's inappropriate, not helpful, but not illegal. And I use the example of sexual harassment, for example. It's not a crime to sexually harass anybody, and it's not even illegal under the laws if that person isn't an employee. It may be tacky, it may be boorish, it may be awful, but it's not illegal, and therefore the laws external to that don't do it. Similarly, if someone engaged in racial epithets, they got up at a meeting or constantly used the N-word or used racial slurs or anti-Semitic slurs in publications or in listservs or that, you may decide that person doesn't extol the values of the organization, is not appropriate for a member. But not only is what they did not illegal, it's protected by the First Amendment of the Constitution in terms of their right to engage in that type of speech, but it doesn't mean that they have a right to they have a right to be associated with your organization if they do. So I think that there are circumstances where the laws of the D.C. and the United States aren't going to do what you need to do, and you still want the prerogative of removing a member.
Thank you. The next person is Lynn Merrill.
This is Lynn Merrill.
Lynn, do you have a question for the Bylaws Committee or for the attorney?
I have a question for Regina, please.
Okay.
But, Regina, I appreciate the answer that you just gave. Hello, can you hear me?
Yeah, you got quiet for a second. I'm not sure what happened.
I don't either. And then the automated voice said, you may now ask your question. Regina, I wanted to thank you for giving the answer that you did to Maria, but there were a couple of areas of blackout. Did you say whether that is required under the code or just allowed as far as removing members?
It's allowed.
Okay, but it's not mandatory?
It's not mandatory.
Okay, thanks. But that wasn't actually my question. I just didn't know if I had missed it previously.
Could you, Lynn, we did explicitly say that people were to ask one question and then to go back in the queue, and we do have other people in the queue. So could you
I just didn't know if I missed it.
Okay, let's go ahead. Ask your question, Lynn.
My question right now is concerning members who are appointed. If they're appointed, then at the very next election, they're elected by the members.
Right.
Do they have to run a campaign, or is there, or can someone run against them?
Someone could run against them.
Okay, so if there are appointed members on the board right now, minus officers, then their seats should be considered in the next election that's coming up in June.
No, because under the law you can't truncate an existing term. It's going to be prospective only. The laws of all nonprofit corporation, all corporation laws are clear that you can't truncate an existing term through amendment, and that's to prevent manipulation of the bylaws in order to kick off someone off the board. And so, that's why that's the general rule, and you'll see it in the bylaws, you'll see it in the statute, you'll see it in just about every statute that no amendment to the bylaws can truncate in an existing term.
Okay. Thank you.
Thank you. The next person is Penny Reeder.
Who's next?
Penny, you are next. And do you have a question for the lawyer or for the Bylaws Committee, or both?
I have a question for Regina. Thank you. Regina, right. I really appreciate your taking all this time to help explain where you're coming from and what the rationale is behind everything that's being changed. It seems to me that there are two ways that one might approach this whole topic, and one would be to look at the code and then see where the Constitution could be changed to meet the requirements of the code, and another might be to look at the Constitution and see what specifically violates the code. I think it would really help all of us if you could somehow clarify what provisions in these bylaws are required in the code and which are allowed. Because one of the things that I don't know that you were able to take into account is the cultural tradition that defined who GDUI was. This is going to be the third question or third mention of the fact that these bylaws allow the board of directors to remove members. And certainly other organizations might allow members to remove members, but that isn't the crux of the matter. GDUI is an affiliate of an organization which was formed when a number of its members were expelled from another blindness organization. So it's been a very closely held tenet of ACB and then of GDUI not to expel members under any circumstances. Certainly we can reprimand members. Certainly we can release a press release and say we're disgusted by this person's behavior, but we don't expel members. And this bylaw seems to me a real violation of that philosophy within ACB and within GDUI. And I wonder, I just would like clarification about which of these bylaws are required to correct something that is actually breaking the rules in the code and which aren't. And I really appreciate your time, and I thank you so much for answering my questions.
I would make one point. ACB's bylaws allow them to expel members. They do. And so without cause, I would add. So I'm not sure it's quite the cultural taboo that you suggest. It's hard to go through and say, generally speaking, the statute has a lot of provisions. These bylaws are model bylaws that we use all the time. They're based on best practices, and it's hard to say which one is absolutely obligated. I will tell you this: you have to have a record date. You have to allow members to apply. You can't make them automatic. You have to give them notice. You have to have an annual meeting. You have to allow them to have special meetings. You have to have a quorum set in your bylaws. The voting, there has to be an explicit voting provision. That's not optional. You can have a meeting by conference telephone call. You can have a meeting by recorded ballot, and it doesn't have to be in the bylaws to put some of those provisions in. The statute has it, but it's considered a best practice if you're going to allow like a recorded ballot or a teleconference that you put the provisions in there. You have to specify the number of directors. You have to specify how they're elected. You do not have to have term limits. You have to, if you don't specify a term for the directors, it's 1 year. It cannot be more than 5 years. 3 is very standard and is a carryover. You have to, the members have to have the right to remove directors. The board of directors don't have to be given the right to do it, but it's permitted that they have the right to do it for very limited reasons. The vacancy, there has to be a mechanism for filling vacancies on the board. The board does have to meet. They cannot meet their statutory duty. There has to be a provision for special meetings. It's in the statute. Notice has to be given, although there's some latitude about the mechanism for doing that. You can have action by written consent. You can have meetings by teleconference call. They're not required, but it would be extraordinary if they weren't. It's in the statute. The way the statute's written, you have the authority to do it unless the bylaws provide otherwise, but it's typically put in the bylaws. You have to have a president. You have to have a treasurer. You have to have someone who carries out the function of a secretary. Those are mandated by the law. You have to have a mechanism for electing officers. There's nothing magical about this one. Again, the members have the right to remove officers. Committees if you're going to have committees, you have to specify whether it's a board committee or an advisory committee. The provisions for electing, creating, and appointing people to the board committees are mandatory. The indemnification is not, there is a statutory mandatory indemnification. Generally speaking, you don't have to put the indemnification provisions in the bylaws. They're in the statute. This is what the statute says. So whether you don't have to put in the bylaws, but you want, to the extent that you want to make it clear how you're going to act, it's good practice to put them in the bylaws. But the statute does have the indemnification provisions, which the old law didn't. The miscellaneous is more things to have than not to have. The amendment provision, again, it doesn't have to be in the bylaws, but this is what the statute provides. The 2/3 vote is a carryover to what you did before. It doesn't have to be 2/3. So without going through all of that, that's sort of a summary of, as best I can, about, an answer to your question about what has to be there. Most of the stuff in this bylaws has to be here in some form or the other. There's some wiggle room, like how many days notice. You can have 10 days notice or 60, anywhere from 10 to 60 days for prior notice of a membership meeting, for example. So you're given some discretion as to how you operate within the parameters, but something has to be specified. And so those are sort of the way the statute's drafted. It was just easier to start fresh with a new set of bylaws than to try to make so many amendments and changes to the current bylaws that you have. And I think that if you look at these and compare them to what you can find online as other models, they're not going to be dramatically different. And it's the form that we have used with a lot of other organizations. So, as I said, it is a legal document first and foremost. That's its primary purpose. And so, I don't think it violates sort of the spirit of the mission of any organization for just a nuts and bolts explanation of how you do things.
Regina, also, isn't it the bottom line that basically GDUI needs new bylaws that are legally compliant because what GDUI has currently is not legally compliant, and the law took effect on the 1st of January 2012?
Okay. And any other questions, Laura?
There's two people in the queue, and one of those people has not asked a question yet.
Okay.
So it's Darla Rogers.
Hi, this is for either the committee or Regina. In talking about elections, I think ours are done telephonically. I don't understand how those are counted, and so that everybody is comfortable that everything went according to plan.
Darla, the telephonic system actually records everything. It's starting in 2008. The system that GDUI implemented back in 2008. The telephonic system, actually, when people call in and vote, all of the everything, your whole ballot, everything is recorded in the electronic system. There's an actual computer, I guess you call it a database, or it's a computer record of everyone's vote, and everything is recorded and locked in. This is the system that was actually, it's been in effect. So that's how it's been that way since 2008.
No, I wasn't questioning that, but don't they ultimately have to be hand counted?
No, they're reviewed of an independent person. And since 2008, this has been GDUI's practice that an independent person goes over the whole electronic record and verifies it. They double check. It's a double check. But initially, all the numbers, everything is recorded in the system.
Thank you.
So,
okay, and I think you have one more question, Lori?
The other person is somebody who has already asked a question.
That's okay. I'll take it.
Okay, and then I guess, okay.
We'll wind up. I'll
all right.
Closing remarks.
I know we keep running over the same old ground of
One second. This is Robert Hache from Massachusetts.
Thank you very much. I know we keep running over the same old ground of this whole thing about, eliminating or expelling or removing members, whatever you want to call it. as Penny said, it has been at the heart of how this organization was created. And I just wanted to point out that while that is allowed to happen by ACB, it does say after a hearing, which implies cause. And I think a lot more people would support these bylaws if that were made to be similar. I think that is something that, and it's not something that needs to be in there to be in compliance. Obviously, we want to be in compliance with the law. There are a lot of good things in this provision, but I think this particular provision sort of gives it a taint that is going to make a lot of people very concerned about this.
Bob, I think that the lawyer has gone over this again and again.
Lori, let me respond to that, please. I want to read you the provision. An individual's membership may also be terminated by a 2/3 vote of all directors in office at the time, and for other reasons, if a member is provided with notice of the meeting at which such termination will be considered in accordance, and they have to be given the same notice as the directors themselves, the same advance notice. Such notice shall also include the reason for the proposed termination. The member shall be given an opportunity to address the proposed determination in writing or in person before the board of directors. In that sense, it's identical to what's in ACB. There's nothing in ACB that requires cause, and cause usually it's not stated. Here, the people are given notice of that their membership will be terminated. They're told the reason why, and they are given an opportunity to address the board either in person or in writing, because I realize sometimes it's logistically not possible to do it in person. So I think in that sense they really are identical. I don't think they're different. So if what is an ACB implies cause, then I think this implies cause, or not, depending on your point of view. I'm not sure that there is a substantive difference there. I think it's just a really question of, having a good procedure so that people have the opportunity to be heard.
Another point is, and this is, I don't think something that's actually been explicitly stated, and you've explained this to the board, is that the person, if a member, I don't know what this big fear of a member being expelled is really based in terms of the fact is that if a member in the future, after these bylaws, hopefully they are adopted, because we really need them, and you've done a fabulous job of helping GDUI to get compliant bylaws. But the point is that if a member after adoption of these bylaws should happen to do something egregious, like become a gay basher or become a racist, who uses GDUI's name to spread hate, or who does something egregious to their guide dog, or some other infamous, horrible thing, at that point, GDUI's board could decide to make a decision. But this doesn't go retroactive. There's nobody who has ever done something. Suppose Inky's handler was a GDUI member. We can't expel him now, because nothing from the past can. And that was something you clearly explained to us. And I'm not sure if that's something. I don't know where the paranoia is coming from. I really can't imagine why anybody would have a paranoia about something so obviously good for the organization. But anyway.
Can I just add one real quick thing? Sorry, I'll go ahead, Regina.
I was just going to say, I'm not, I wouldn't, Laura uses the word paranoia. That's not a word I would use. I understand that because of the conflicts within the organization, there's some anxiety on this point, and I appreciate that fact. But I think that it may be time to just draw a line under everything and say, going forward, we're just going to be we're going to learn to, we have to operate on the assumption that everybody's working for the best interest of the organization and in good faith, and say it's time to put the past behind you. My sense is that everything I've done with the board is that they are committed to that. They're not looking to relitigate the past couple of years. What's done is done. I don't think that, as I said, every set of bylaws I saw had some provision like this in it. And like depending, no matter how you do it, it can be, the people are not operating in good faith. It can be abused. That is true. But but again, back to the point, which is any method for removing members can be abused. And the check here is that if you have a board that's abusing the members, you remove the directors. That's your power. Whereas if you have people who are manipulating a membership provision, there you really don't have any remedy. You can't assume that just because it's done by the members that it's always going to be done in good faith and without abuse. And there, if it's done at the membership, there really is no check. Whereas here, there is a check on the board in the sense that if they do get to the point where they are abusing their authority, you can remove the members of the board, either immediately or at the next election. And so, some people have said there's no check, and that there is a check. The check is the members themselves. And so I just want to point that out.
Can I just add one real quick thing that may help you guys a little bit? I do want you to know that neither the Bylaws Committee nor the board initiated this expulsion thing.
That was me. I take full responsibility because it's a common feature in every set of examples that I looked at, that there be some mechanism for dealing with these situations. I was not told to put it in. That's a good point, Mary Beth. Thank you.
You're welcome. Well, I hate to shift the blame or whatever, but I wanted you guys to know that. And one other quick thing, as you know, elections come up after the bylaws. If the membership is going to have an opportunity to elect lots of new board members, and I think that you should just also bear that in mind as you consider these bylaws.
Well, thank you, Regina. You've been so generous with your time.
Thanks.
2 hours in your evening.
It's my pleasure. Can I just say, we're going to have another call on April 7th. If people send the questions in writing in advance, it will be easier for me to respond. I think that's helpful for me because it gives me a chance to check on things and look at them. So I encourage people, to the extent they haven't done so up to this point, that they send their questions in advance in writing. They will be answered first, and it'll be more complete answer.
And just so you know, I'm sorry, every question that goes to that bylaws at GDUI.org really does get looked at by Regina.
Mm-hmm.
I don't have some slush file where I keep, somebody's questions. I don't want to send that one through. That's not how it works.
So anyway, we thank you very much for your time
this
evening.
Thank you all. Thank you for the privilege of working on this.
Well, thank you. We appreciate your help.
Okay.
Thanks a lot. Bye, everybody.
And again, she did say that would be the last call, and that we would wind up for this evening. It's already after 9, so I hope everybody found this helpful, and we look forward to our April 7th call. Thank you, everybody.
Thank you.
Thanks, Lori. Bye. Thanks, Regina.
Bye.
Bye.
Hi, Mary Beth, you're still there?